Hi, I'm Brian Heidelberger, a partner with the law firm of Winston & Strawn in Chicago, and here today with another mini advertising law lesson. Today's law lesson in advertising agencies' liability and responsibility when substantiating advertising claims. But first, all you advertisers, don't shut the video off yet. This does apply to you. And why is that? Because you are involved in this process with the advertising agency, and you should know of the concerns the agencies will have when they talk to you about claim substantiation. So what is the issue? Well, this stems out of a recent case settled between the FTC, the Maine Attorney General, and a company named Synergix and its owners, whereby they settled Synergix for $6.5 million for some false advertising that it created for its clients. Now, what happened here is Synergix and its principals produced 30-minute radio ads for a product called Coniprin and Flexprin. And the FTC and the Maine Attorney General believe that these ads were deceptively formatted to sound like educational talk shows when in truth and in fact they were commercials. The FTC also alleged that Synergix and its principal had created these call scripts that had deceptively claims that consumers could try it risk-free, when in fact and in truth there were a lot of hoops that consumers had to jump through, and there was an auto ship function to get the free trial. You had to sign up for that auto pay, and that was not appropriately disclosed. Now, importantly, this claim came against the party who produced these radio commercials. It's very important to understand as an advertising agency that you have independent responsibility regardless of whether or not the client who manufactures the product, who paid for the advertising, is taking responsibility vis-a-vis your contract with them, and whether or not the client has approved the message. And why is that? Well, it goes back to FTC substantiation policy, as well as some very old cases which are still being enforced today. And the FTC has said that an advertising agency, or even if you're not called an advertising agency, but a direct marketing company, an influencer agency, anyone who is producing marketing materials on behalf of another company can be liable if they were an active participant in the creation and if they knew or should have known that the advertisement was deceptive. Now, specifically, the FTC said that an ad agency will be held to know what claims, both those that are expressly stated and those that are implied in the ad, and that are conveyed to consumers by the ads. The agency doesn't necessarily have to independently substantiate the claims themselves, but they certainly need to go to the client, ask the client what substantiation that they have, take in that substantiation, look at it to make sure that it looks reasonable, and then keep it in their files. Notably, it's not enough just for the client to say, we have appropriate substantiation. The agency needs to do more than that. And that's why advertisers, if you're still watching this video, you need to understand that regardless of what your contract says with the agency, it's not unreasonable for them to ask what substantiation that you have and for them to ask you to produce it to them so they can look at it. Now, they're probably not going to nitpick it, but they need to make sure under FTC rules that that substantiation is reasonable, and they need to have it in their files. Now, the FTC has a policy statement on their website that you can find that specifically answers the question, are advertising agencies subject to the FTC Act? And the statement says, yes, ad agencies have a duty to make an independent check on the information used to substantiate ad claims, and they cannot just rely on an advertiser's assurance that the claims were substantiated. Ultimately, the FTC policy statement says that the agency can rely on the advertiser's substantiation unless the agency is aware that the substantiation doesn't exist, they're aware that it's false, or otherwise it just seems unreasonable to support the claims. These are important facts for both agencies and advertisers to be aware of when substantiating claims. And obviously, the stronger the claims, the more health-related or safety-related, or the more that these claims are going after kids or populations that may be disadvantaged, the more the FTC is going to be interested in protecting these groups. So I hope this information was helpful, and until next time, let's be careful out there.